Your presenter.
Max, are we ready?
Just a minute. Shad is was having computer issues, and he's going to be right back.
Okay.
Test, test. Oh, all right, I guess we can go ahead and get started.
Okay, good morning. Is Thomas with us?
I am at this time.
All right, Thomas, I had a question. We started the annual chair and co-chair or before we start the agenda, or can we just do that at the end?
They do that at the end if you so choose.
Okay, then we'll just stay with the agenda the way it is. All right. Good. Sorry for having patience while we get our technical issues worked out. The January 2021 meeting of the Charlotte Zoning Board of Adjustments is now in session. I am Rick Sanderson, chairperson. Max, can you mute people? I'm hearing a feedback.
We can try. Hold on, we have building staff here. Just 1 second.
I brought it here, I didn't know if you tried it. I'm connected to the internet here. Oh, we don't have Wi-Fi. It's on my Wi-Fi? Yeah. On my Wi-Fi? Yeah. Yeah, we don't have Wi-Fi. It's not working. Well, yeah, I mean, I'm sitting and I tried to plug in from the office. Plug it, it kicks me out. Say mad that it's just password. Yeah, that's not, kind of spot. Where's the minute? Yeah. I don't know. Well, yeah, I mean, I'm sitting there trying to plug it from the office.
Hey Lisa, turn off the mic. Turn off your mic and mute, please. Then log out, please. Turn off your mic.
So my program, I can't see it.
That's all right. Log out and then restart it. Yes, Max, we can't hear you at this time. We hear you very loud and clear.
Can you hear me?
Lisa, are you in the same room as Max?
Yes.
Then if you're in the same room as Max and Max also has one of the actual mics on, then you can't have a mic on as well. So one of you need to pick a mic. Otherwise, we're going to get feedback for the entire meeting since both of you are in the same room.
God loves them better, I guess. Try.
We appreciate the
Yeah, sorry, I just don't really know all the weather.
Yeah, that's fine, understand.
Have a good one.
Thank you. Oh, I had to change host, so I'm gonna make you presenter again. Let's see. Yeah. Is it-
Hey, Max.
Yes, yes.
While y'all working on that, can you mute yourself? I'm going to try to ask the chair if he wants to go ahead and conduct other business like adopting the minutes. So while y'all handling that, we can kind of continue to move the meeting forward. Mr.
Okay.
Chair,
Thank you.
Rick? Hey, Max, can you unmute the chair?
He's working on that.
Thank you.
Okay.
There
I'm
we
here.
go. All right, Mr. Chair, while Shad and Max and Lisa are working on everything else, I think at this time, to at least, use this time wisely, if you want to, you may adopt your minutes, or if you want to kind of also consider the chair, vice chair for next month's meeting, while Max and Shad and Lisa work on the logistics.
Okay. Or do I need to read the chair speech first, or can I just go to the business?
I think you can go straight to the business without reading the speech. The speech will be
Okay.
when we kick off the actual hearings.
All right, let's go ahead and do the minutes first. I think it's December 8th meeting. Everybody have a chance to review. I did and got to Mac. Minutes. I don't know, board members.
They should be able to mute and unmute themselves as normal.
Okay.
They're all panelists.
And just to confirm, Douglas, are you on the call? On the video? John Floyd, are you on the video?
I'm here.
Okay. All right.
See Krista on the video.
I see Krista. So Douglas just popped on. So I got Douglas, Krista, and John.
Patrick was on the.
Well, given that you do have 4 board members at least, you can go ahead and actually transact business at this point. At least for the
Okay.
purposes of the minutes and maybe the selection of the chair and vice chair, you can do that.
Okay, is there a motion to approve the December 8th meeting minutes?
Motion to approve the December 8th meeting minutes.
We have a motion by Mr. Floyd. Is there a second? Either Douglas or Krista.
Right, there we go.
Can you guys hear me?
Yeah,
Yes.
I was unmuted. Sorry about that. I couldn't unmute myself at the time.
Okay, is there a second?
I second.
Okay, we have a motion by Mr. Floyd and a second by Mr. Wilson to approve the December 8th meeting minutes. We'll take a roll call vote.
Yes.
Mr. Wilson,
Yes.
Krista,
Yes.
okay, I just saw Mr. Welch. Are you,
Yes.
okay, and Sanderson, yes, approved. Every year we have to elect a chair and a co-chair from the members of the board. The current members of the board are myself, Deborah Dryden, Patrick Welch, and Krista Long. We have Mr. Wilson and Mr. Floyd are alternates. So Thomas, it's my understanding that it has to be a member, not an alternate. Is that correct?
Excuse me, that is the typical process in regards to voting for chair and vice chair. However, at this time, I think given the, if we do not have any of the regular members at this moment, I think you may proceed accordingly. I think if anyone on the committee wishes to object, they can object, but if no one wishes to object, I don't think it will be invalid.
We currently have, I think, is Mrs. Dryden on?
Yes, Mr. Dryden was on. Also, Patrick is Mr. Welch is a regular member, and so is Miss Long.
Okay. Yeah, so we have all the members are on a motion for, or to elect a chairperson.
I move to appoint Rick Sanderson as the chairperson.
Okay. Is there a second?
I second Patrick Welch.
Okay. Rick Sanderson as the chairperson. We'll take a roll call vote. Do we need to, I'll take a roll call vote. Mr. Floyd,
Yes.
Mrs. Dryden, back to you, Mr. Welch,
Yes.
Long,
Yes.
Yes.
All right, Mrs. Dryden. I would make a motion for a vice chair. That would be the person that would run the meetings if I was not able to be here or if I had a conflict. The way I understand it, he's a board, an actual board member, not an alternate. So that would be either Mrs. Dryden, Mr. Welch, or because we have one vacancy on the board due to Terry Brown's resignation to be a state congressman. So is there a motion?
I nominate Patrick Welch.
Okay.
I second.
Floyd for Patrick Welch. Is there a second? Okay, we have a second. Mrs. Dryden. Patrick, are you okay with that?
I'm fine. Perfect. I'm perfectly fine. Thank you.
Let's take a roll call vote. Mr. Floyd,
Yes.
Mrs. Dryden, Mr. Wilson,
Yes.
Long,
Yes.
Sanderson, yes. Mrs. Dryden, Welch will be the vice chair or the co-chair for this year. Okay, Max, are we ready to move into the hearing?
I don't think Lisa's on yet. Oh, she is. Just kidding. Let me- Lisa's saying that her computer froze. So it may just be a minute.
I think I'm on now. Can y'all hear me?
Yes.
Okay, can you make it so I can see the screen?
Okay, let's try this. Are we ready to go, Max?
I believe so.
Is Candy ready?
Yes, she is.
So we'll try this again. The January 2021 meeting of the Charlotte Zoning Board of Adjustments is now in session. I am Rick Sanderson, the chairperson. So sitting on today's board is Deborah Dryden, Patrick Welch, Krista Long, Douglas Wilson, and John Floyd. Also present are Shad Spencer, the planning administrator, Lisa McCarter, the planning administrator, Therese Hagler Gray, senior assistant city attorney, Thomas Power, senior assistant city attorney, Jill Sanchez Meyer, senior assistant city attorney, Max Oliver, clerk to the board, and Atkins court reporting verbatim reporter. I'd like to start by acknowledging that we are conducting this meeting using a remote electronic platform. Charlotte Zoning Board of Adjustment, and I would like to ask for your patience today. As we proceed, there may be some slight delays as we transition between speakers, participants, and presentations. The Zoning Board of Adjustment is a quasi-judicial board body that is governed by the North Carolina General Statutes and the Charlotte Zoning Ordinance. We conduct evidentiary hearings on request for variance and appeals, among other requests. Before we begin to hear the cases on today's agenda, I would like to provide some important information on the steps that are taken to ensure that each party's due process rights are protected as we proceed in this remote platform. First, today's meeting will be conducted in accordance with special legislation passed by the North Carolina General Assembly in session 2020-C that allows for remote meetings and quasi-judicial hearings during declarations of emergency. Second, each applicant was notified before being placed on today's agenda that this meeting would be conducted using a remote electronic platform. Every applicant on today's agenda has provided signed to the board prior to conducting the evidentiary hearing on their request using this remote platform. Third, notice of this meeting was provided to the applicant's public in a number of ways. Notice of today's hearing is mailed to property owners within 300 feet of each subject property and notified
Easy
owners of the
transition.
remote electronic platform. And the letters also stated to contact the city immediately if there were any objections to the cases being heard on today's agenda. Please. Notice was also provided by placing signs on each property and by publishing notice on the city's website. The notice means by which the public can access today's proceedings. Finally, any individual in today's proceedings. Today we'll be hearing one type of case. Application for a variance from the regulations in the zoning ordinance. The order of the recommendation agenda will be as follows. The zoning administrator or a zoning staff member will identify the case and recommend approval of the variance with any recommended conditions based on specific reasons. The chairperson will ask if anyone wants to speak in opposition. If there is such a person, then the case will be moved to the regular agenda and will be heard at a later date. The chairperson will ask if the board has questions for staff or if there is any reason for the board wishes to move the case to the regular agenda. The chairperson calls for a motion and a second variance. The chairperson will hold a roll call. All parties who plan to give testimony pro or con must be sworn in. The zoning staff member will explain why a permit was denied or why a variance is requested. The board may question the staff member, and then the applicant may question the staff member. The applicant presents their testimony for their case. The board may question the applicant, and the staff member may question the applicant. The applicant may present sworn witnesses. They will be subject to questioning. Other parties wishing to speak pro or con will be given reasonable time to present sworn testimony. Excuse me. Staff and then the applicant will be given an opportunity for rebuttal. The chairperson calls for a motion and a second to approve the variance. The person will hold a roll call vote. After hearing each case, the board will review each case and render a decision. This is usually done in closed deliberations after hearing each regular agenda case. However, the board may elect to take up to 30 days to render a decision. You may remain present during the deliberations, or you may call the zoning staff after the session to receive them. All exhibits must remain with the board. Exhibits were required to be provided to the clerk no later than 12 p.m. on Monday, January 20, in order to be considered at this hearing. If your case is not appealed to Superior Court after 30 days, you may pick them up and they will be. If you feel there is a conflict of interest of any member of the board or an association that would prejudice your case, please let it be known at the start of your case. The board has judicial capacity for purposes of this hearing and can only accept sworn testimony. While the board would not specifically exclude hearsay evidence, it is only given limited weight. The North Carolina State Bar has issued an advisory opinion that it is the unauthorized practice of law for an individual who is not an active member of the bar to appear for another or otherwise assist or represent another judicial hearings on zoning and land use matters. All applicants should have been provided with a copy of that advisory opinion as part of the application packet. If you are a property owner or a non-lawyer here on behalf of a property owner and have not received a copy of that opinion, please use the WebEx platform. The documents will then be provided to you. If, as a result of this advisory opinion, the applicant would like to request a continuance of his or her case, the board will consider such a request at the start of that case. Appeal from the board is to the Mecklenburg County Superior Court. You have 30 days from the date of the board's written decision in which to appeal, in accordance with North Carolina General Statute 160A-388E. In order to request a written copy of the decision, any aggrieved party must file a written request for a copy of the board's decision by filling out the form, which must be filed with the board's clerk or chairperson at the time of the hearing of the case. Please remember to mute your microphone when you do not intend to speak. We will hear 8 cases today, 6 recommendation agenda item cases, and 2 regular agenda item cases. The first case is case number 2020-113 for the property located 417 Centerfield Drive, presented by Lisa McCarter. No, anyone who opposes any cases today. Will those who plan to give testimony and today affirm the following? So right now, let's just do Shad and Lisa. Do you swear to tell the truth, the whole truth in the matter at hand?
I do.
I do.
Okay. Thank you. Max, is there anybody signed up to speak against the first?
No one has signed up to speak in opposition to the first case.
All right, thank you. Lisa, you can go ahead and start. And Max, will you send out the findings of fact and conclusions of law to the board members, please?
Yes, I'll do that.
First case is case number 2020-113. It's a residential setback variance. The applicant is requesting a 13-foot variance from the required 20-foot setback in order to construct a new home. And I'll give you a moment to look over your findings.
Yeah, I'm sorry, but when were the findings of facts sent out? I don't have those in my email.
They were sent out just now. You'll have them momentarily.
Okay, all right.
Go ahead, Lisa.
Okay. Government exhibit number 1 is the vicinity map of the property. Government exhibit number 2 is the zoning map of the property. The property is zoned R5 single family. Government exhibit number 3 is an aerial map of the property. And government exhibit number 4 is a close-up aerial map of the property. Government exhibit number 5 is background. The property was subdivided in October 2000. The subdivision plat showed a 50-foot railroad right-of-way through the rear of the property. This left approximately 45 feet of allowed building depth at the time of subdivision. Government exhibit number 6 is background. In December 2002, Duke Energy purchased easement over most of the property to use for transmission line right-of-way. And you can see it's lot 9 on the plans. Government exhibit number 7 is the variance request. After the Duke Energy easement was acquired, it left only about 14 feet of allowed building depth on the property. The applicant requests a 13-foot variance from the required 20-foot setback. Staff supports the requested variance. A 7-foot setback would allow approximately 27 feet of building depth. Government exhibit number 8 is a consideration that the requested variance is in keeping with the neighborhood character. 3 other setback variances to allow setbacks ranging from 6 to 15 feet have been granted for property along Centerfield Drive due to the railroad right-of-way and the Duke Energy easement, and they're marked with the yellow stars. Government exhibit number 9 is another consideration. Granting the requested variance upholds safety. The applicant states that a 20-foot driveway can be located to the side of the proposed home to allow parking and maneuvering and ensure vehicles are not parked in sidewalks or yards. Government exhibit number 10 is a photo of the property. And that's my presentation if you have any questions.
Okay, thank you, Lisa. Are there any questions for staff?
So Lisa, this is the same street. We heard kind of similar variance requests back in October, right? Same applicant and everything.
Correct, yes.
And they're also the next two cases are on the same street.
Yes, and they're very similar.
Mr. Chair,
Yes.
I anticipate you're going to ask me the question of whether you could consolidate all of these cases into one to kind of expedite today's meeting. If you're wanting to consider that, I'm not going to say you should not, but I definitely would say if staff has additional information for all the other actual applications that are different from this one, they could present that, and you could either adopt or reject or approve with conditions, all of them, because it's the same applicant, they're all on the same recommendation agenda in that regard.
Okay, thank you, Mr. Powers. If we don't have any questions, if the board members don't have any questions of concern or concerns with this case, then we've gotten through it pretty quickly. So I think we should just go ahead and do the next two cases individually as well, if that's the case. Is there any questions for staff or any reason that the board members think that this case should be moved to the regular agenda? Or is there a motion to approve?
Motion to approve.
Second.
We have a motion by Mr. Floyd to approve variance. We have a second by Mr. Wilson. We'll take a roll call vote. Mr. Floyd?
Yes.
Yes.
Ms. Long, okay, Mr. Welch,
Yes.
and Mrs. Dryden.
Yes.
Sanderson, yes. So the members that were voting on this case for the court reporter were Sanderson, Dryden, Welch, Wilson, and Floyd. That's approved unanimously. Let's look at the findings of fact and conclusions of law. I didn't see anything.
There was only one item, Mr. Chair, I would recommend for the findings of fact. Number 5, it says register of deeds, and deeds is lowercase, so I would capitalize, excuse me, the D for deeds.
Okay. Thank you, Mr. Powers. Is there a motion to approve?
I move that we approve the findings and facts of law.
I'll second.
Welch to the findings of fact and conclusions of laws. Roll call vote. Mr. Wilson,
Yes.
Couldn't hear you.
Oh, I said yes. Chairman.
Patrick, we couldn't hear you.
Yes.
Okay, thank
Yes.
you. Mr. Floyd,
Yes.
Mrs. Dryden,
Yes.
Sanderson, yes, so that's approved. So the next case is 2020-114. Let's go ahead and keep the same 5 members on, since it's very similar to the previous one. So it'll be Sanderson, Dryden, Welch, Wilson, and Floyd. Go ahead, Lisa.
Okay, case number 2020-114 is a residential setback variance. The applicant is requesting a 12-foot variance from the required 20-foot setback in order to construct a new house. And I'll give you a minute to look at your findings.
Max, will you please go ahead and send out the findings of fact for all the cases, please? Right now, we need the one for 114.
Yes, I sent the ones for 14 and 15. 114, 115.
It hasn't come through on my end yet. Up, just got it.
Hey, Lisa, you can go ahead and start.
Okay, exhibit number 1 is the vicinity map for the subject property. Exhibit number 2 is the zoning map. The property is zoned R5 single family. Exhibit number 3 is the aerial map. Exhibit number 4 is a close-up aerial map. Exhibit number 5 is the background. The property was subdivided in October 2000, and the subdivision plat showed a 50-foot railroad right-of-way in the rear of the property, which left approximately 45 feet of allowed building depth. Exhibit number 6 is background. In December 2002, Duke Energy purchased easement over most of the property to use for transmission lines. Exhibit number 7 is the variance request. After the Duke Energy easement was acquired, it left only about 16.5 feet of allowed building depth on the property. The applicant requests a 12-foot variance from the required 20-foot setback. Staff supports the requested variance. An 8-foot setback would allow approximately 28.5 feet of building depth. Slide 8 is a consideration. The requested variance is in keeping with neighborhood character. 3 other setback variances have been granted to allow setbacks ranging from 6 to 15 feet. Exhibit number 9 is another consideration. Granting the requested variance will uphold public safety because the applicant said that they can provide a 20-foot driveway located next to the house. So that is my presentation. If you have any questions.
From the board. Max, did anybody sign up to speak in opposition?
No one has signed up to speak in opposition. Yes.
Okay, is there any reason the board case should be moved to the regular agenda? Hearing none, is there a motion?
Motion to approve the zoning request, Dryden.
I second Wilson.
We have a motion by Mrs. Dryden, a second by Mr. Wilson to approve the variant. Take a roll.
Dryden, yes.
Mr. Wilson,
Wilson, yes.
Floyd,
Floyd, yes.
Mr. Welch.
Welch, yes.
All right, that's approved. Sanderson, yes. Approved unanimously. Let's look at the final conclusions of law. I think it's the same thing on with the Register of Deeds. The word deeds needs to be capitalized. Did you, Thomas?
No additional comments, Mr. Chair.
Thank you. Is there a motion to approve the findings of fact conclusions of the law as revised?
Make a motion to approve as revised.
Thank you, Mrs. Dryden. Is there a second?
Second.
We have a motion by Mrs. Dryden, a second by Mr. Floyd to approve the findings of fact and conclusions of law as revised. We'll take a roll call vote. Mrs. Dryden?
Yes.
Mr. Floyd?
Yes.
Yes.
Mr. Welch?
Yes.
Sanderson, yes. So those are approved. Our next case, 5. Lisa, is there anything significantly different in the write-up for the findings of fact and conclusions of the law for this case versus the previous 2?
There's not. The only difference is this one had a required 35-foot front setback per plat, and the others had 20, but that's the only difference. So we still support the requested variance.
Then you just go ahead and do the presentation then. If there's no significant difference, I think we need to take a few minutes to read through it, but
Okay.
I'll scan through it. But go ahead and do the presentation.
Okay, case number 2020-115 is another residential setback variance. The applicant's requesting a 23-foot variance from the required 35-foot setback in order to construct a house. Exhibit number 1 is the vicinity map. Exhibit number 2 is the zoning map. Exhibit number 3 is an aerial map. Exhibit number 4 is a close-up aerial map. Exhibit number 5 is background. Property was subdivided in October 2000. The plat shows a 35-foot front setback for the lot, which supersedes the R5 set 20 feet. The subdivision plat also showed the 50-foot railroad right-of-way running through the rear of the property, which left approximately 30 to 84 feet of allowed building depth. In 2002, Duke Energy purchased easement over most of the property. Exhibit number 7 is the variance request. After the Duke Energy easement was acquired, it left only about 30 to 1.5 feet of allowed building depth on the property. The applicant requests a 23-foot variance from the required 35-foot setback. Staff supports the requested variance. The 12-foot setback would allow approximately 25 to 53 feet of building depth. Slide 8 is the consideration that there were 3 other setbacks granted on Centerfield Drive. And exhibit number 9 is the consideration that it upholds safety because a 20-foot driveway can be installed beside the home. And exhibit 10 is a photo of the property. And that's my presentation if you have any questions.
Thank you, Lisa. Are there any questions for staff? Max, did anybody sign up for and speak in opposition?
No one has signed up to speak in opposition of this.
Okay. Does anybody on the board think that this case should be moved to the regular agenda? Okay, hearing none, is there a motion? We have the same 5 board members on this case: Anderson, Dryden, Welch, Wilson, and Floyd. So is there anybody that wishes to make a motion or discuss this case?
Dryden, I'll make a motion to approve this variance.
I second the motion.
A motion by Mrs. Dryden, a second by Mr. Wilson to approve the variance. Take a roll call vote. Mrs. Dryden,
Yes.
Mr. Wilson,
Yes.
Mr. Welch,
Yes.
Mr. Floyd,
Yes.
Sanderson, yes. It's case number 2021-15 is approved. Finds of facts and conclusions of law. The only thing scanning through it was the register of deeds, the capitalizing the word deeds on number 5. I didn't see any else.
I make a motion to approve the finding of facts and opinion as amended.
Thank you. Dryden. Is there a second?
I'll second.
Is that Mr. Welch?
Yes.
Okay, thank you. We have a motion by Mrs. Dryden and a second by Mr. Welch to approve the findings of fact and conclusions of law as amended. We'll take a roll call vote. Mrs. Dryden,
Yes.
Mr. Welch,
Yes.
Yes.
Floyd,
Yes.
Anderson, yes. Okay, those are approved. The next case, I believe, is case number 2020-127. Is anybody that has any on this case? Let's have Mrs. Dryden, Mr. Welch, Ms. Long, and Mr. Wilson as the board members. She already sent this one out.
That's correct, I did.
Will be the findings of fact and conclusions of law.
The next case is 2020-127. It's a residential rear yard variance. And the applicant is requesting 2 variances to construct a second story on a non-conforming detached accessory structure. They're asking for 1.4 feet from the 3-foot side and accessory yards. So I'll give you a minute to look over your findings.
Okay. Please.
Exhibit number 1 is a vicinity map of the property. Exhibit number 2 is a zoning map. The zoning of the property is R4 single family, and it's located in the Dilworth Historic District overlay. Exhibit number 3 is an aerial map of the property. Exhibit number 4 is a close-up aerial map of the property. Exhibit number 5 is background. The property was subdivided in October of 2000. Oh, sorry, I was reading the wrong one. There's an existing home on the garage on the subject property. The home was built in 1934 and the garage was built in 1997, according to aerial photos. The 1999 zoning ordinance in effect at the time of the garage construction allowed 2-foot accessory side and rear yards, and encroachment of architectural features were permitted. Today's ordinance requires 3-foot accessory side and rear yards and does not permit encroachments. Exhibit number 6 is the variance request. The existing garage on the property is 1.6 feet off the side and rear property lines. The applicant states that the building is 2 feet from the property lines, and the 0.4-foot additional encroachment area is the overhang. Encroachments of architectural features were permitted to encroach into the 2-foot yards at the time of the garage construction, so the garage is non-conforming since it was compliant at the time of the construction and it predates the current 3-foot side and rear yard requirements. The code requires that expansions of non-conforming structures comply with current zoning requirements, so the applicant is requesting variances of 1.4 feet from the side and rear yard to construct a second story on the currently 1-story garage. Government Exhibit 7 is considerations. Staff supports the proposed variance. The hardship was not created by the applicant. The applicant states the property was purchased after the garage construction. The hardship results from strict application of the ordinance. The applicant provided a letter in their application package from their architect that the design should maintain the existing footprint. The requested variance is in keeping with neighborhood character. Prior to permitting a second story of a garage, a certificate of appropriateness would have to be issued to ensure that the construction is compliant with the historic district guidelines. The requested variance is not easily detected because of its rear yard location, and it won't impact public safety. And I've just got a picture on the screen on the lower right of what the existing front elevation looks like now and what the proposed elevation will look like. And in the top left corner is the architect letter stating that the design of the structure would not work if they couldn't use the existing footprint. Government exhibit number 8 is a photo of the property. That's my presentation. If you have any questions.
All right, thank you, Lee. Max, did anybody sign up to speak in opposition to this case?
No one has signed to speak in opposition to this case.
Mr. Chair,
Any questions for, yes, Mr. Powers?
if you could give me a moment of personal privilege, I need to ask a procedural question to Lisa for the board.
Okay, you're breaking up a little bit, Thomas, so.
Sure. I was asking if I can have a moment of personal privilege to ask Lisa a question. Lisa, just want to
Yes,
verify,
sir.
you mentioned this is HDC application.
Correct.
Just want to confirm for the board as they're deliberating, has the HDC approved this actual application on their end or not?
They have not. I've made them aware of this variance request, so it would still need to have their approval prior to permitting.
Mr. Chair, the reason I was asking that question, and members of the board as well, I do want to make sure you're at least aware of the situation, that because this is now subject to the HDC's review for the architectural elements and other design requirements under the HDC guidelines, that it is possible that you could approve a variance today and the HDC subsequently denied the request later under their guidelines and procedures. So I do want to make sure you're at least aware of this as you're discussing and or deliberating this request for a variance. If you were to actually go down the path of granting the variance, I would ask that the board consider a actual conditional, well, a condition in that regard. But that would be something we would discuss based on, you know, your ultimate decision on this particular case. I can answer any questions that you may have, but I do want to at least just highlight this issue up front.
From a procedural standpoint, should the cases go before the historic commission before they come to the zoning board? I think that's the way it's been done in the past, so we didn't have that potential approval and then denial by the other.
Mr. Chair, you're correct. Procedurally, in the past, we have had it that way where the HDC was the one that would have looked at and reviewed the necessary application and made a decision on that. And therefore, you would not have a situation where you were to grant a variance for X feet and then, you know, the applicant does not get approval ever from the HDC. I can't answer what may have happened in this situation. I think that would be a question for Lisa or Shad. But due to that distinction, I definitely think that is a something you should be aware of.
Thomas, is it possible that we approve this variance, goes to the commission, they deny it, and then it comes back to us the next month or two? Or does it just die over there?
So under your actual procedures, a variance that you will grant an individual is valid for, I think, up to 2 years for use. Under the HDC guidelines, when they actually have an application, state law requires a actual decision, I will say decision, whether adverse or in favor, within 6 months of the actual presentation. So theoretically, if the HDC were to receive an application today, the 6 months would start from the first time it's presented to the entire HDC board. And at that point, if they were to deny it, the applicant could come back with a different type of design and or a future application. As long as it's still within that 2-year period, your variance would still be allowable for them to build the new garage if it was approved by the HCC in that 2 years. Sorry, that's a long-winded answer.
No, it's good. Right. Next.
Lisa, do you know if the petitioner has sent the request to the HDC?
So the petitioner has not sent the request to the HDC. I sent it to the HDC, and in my previous conversations with the HDC, they would like zoning compliance first prior to it going to the HDC for approval for a COA. So that in their process, they actually prefer that it gets zoning approval first.
Thomas, I mean, that's contradictory to what.
So, yes, sir. So procedurally in the past, the ZBA has always said HDC go first. As Lisa's indicated and expressed, it sounds as if Shad and his counterpart for the HDC have worked it out where the zoning board of adjustment would then review the actual request and make a decision first. If it's denied, then there's no need for the HDC to consider the application at all. If you were to grant it, then the HDC would look at the application, understanding that this variance allows for a greater setback and an opportunity to construct the actual project. So based on that administrative aspect, it sounds as if they're okay with you moving forward. I at least just want to make sure you're aware of that in that regard.
Is that correct, Shad?
Yes, that is correct. And it's something we've dealt with also with rezoning. Sometimes an applicant will need a variance before they can proceed with a development that needs a rezoning. And so years ago, it was told to us by the zoning board of adjustment that if another board goes ahead and approves something, they feel like they're pressured at that point. Like if city council approves a rezoning, knowing that they need a variance, then it's kind of like the zoning board of adjustment feels like, well, we're kind of obligated to grant the variance because the city council already approved it. So it was then turned around so then that it would come to the zoning board of adjustment first to evaluate it and then either grant or deny variance. So we've kind of used that same practice with HDC as well.
Okay. Yeah, I guess it's the way it sounds is it's up for us to review this first to make a decision, and then it'll go back to the HDC based upon our decision. So we'll go ahead and proceed that way. Thank you, everybody, for your explanations of how the process works. So is there any questions for staff from the board members? Yes. Is there any reason the board wishes to move this to the regular agenda? Is there a motion to approve or deny the variance?
I make a motion to approve the variance, Wilson. Sorry about that, Deborah.
That's okay. I'll second.
Okay, we have a motion to approve the variance for Mr. Wilson, a second by Mrs. Dryden. We'll take a roll call vote. Mr. Wilson?
Wilson, yes.
Mrs. Dryden?
Dryden, yes.
Long, yes.
Welch,
Welch, yes.
Sanderson, yes. So it's approved. Looking at the findings of fact and conclusions of law. Thomas, do you have any wording for that condition that you think we should put on it, or should we just approve? Should we go with the way it's currently written?
I think you can go the way it's currently written. Given Lisa and Shad's explanation of the tweaks of the process, I don't think the condition is necessary.
All right, thank you. I didn't see anything in the findings of fact and conclusions of law. So, is there a motion to approve or any revisions that need to be made?
I make a motion to approve finding of facts as written.
I'll second the Welch.
We have a motion by Mrs. Dryden and a second by Mr. Welch to approve the findings of fact and conclusions of law. We'll take a roll call vote. Mrs. Dryden?
Yes.
Mr. Welch?
Welch, yes.
Ms. Long?
Long, yes.
Mr. Wilson?
Wilson, yes.
Sanderson, yes. So those are approved. I believe our next case is 2020-128. The members on this one will be myself, Mrs. Dryden, Mr. Welch. Are there any board members for this? Okay, hearing none, go see.
All right, the next case is case number 2020-128. It's a residential watershed buffer variance. The applicant is requesting a variance to allow development within an existing encroachment into the 100-foot watershed buffer. It includes a home addition and the removal of an existing built-upon area. And I'll give you a minute to look at your findings.
Okay, go ahead, Lisa.
Okay. Government exhibit number 1 is the vicinity map of the property. Government exhibit number 2 is the zoning map of the property. The property is zoned R5 single family, and it's located in the Lake Wiley Critical Area Watershed Overlay. Government exhibit number 3 is an aerial map of the property. Government exhibit number 4 is a close-up aerial map of the property, and it shows the 100-foot watershed buffer off of Lake Wiley. Government exhibit number 5 is background. The property was subdivided in 1958, and the home on the property was built in 1960. The home predates the watershed overlay requirements in the zoning ordinance. Government exhibit number 6 is the variance request. The existing home on the property encroaches approximately 40 feet into the required 100-foot watershed buffer and is a non-conforming structure. So you can see where I marked up where the back of the deck is about 60 feet from the shoreline. The applicant wishes to make property improvements, including the removal of a structure, which you can see where the applicant has circled remove structure, and that structure is about 45 feet from the shoreline, so a little bit closer than the home is. And also put in a home addition in that deck area in the 100-foot watershed buffer. The code requires expansions of non-conforming structures to comply with current regulations, and that would mean anything new would have to stay out of that 100-foot watershed buffer. So the applicant is requesting a variance to utilize the existing 40-foot encroachment into the 100-foot buffer to build an addition onto the rear of the home. Staff supports the requested variance. The applicant has verified that city sewer is not available to the property, and he must maintain the current septic system, so that would prevent any heavy equipment operation or building in the front of the home. And you can see where the applicant has marked on the survey where the septic field and the septic system is located. The area of the addition on the rear of the home is currently a deck, and it's got impervious surface underneath it. So since the improvements include the removal of another structure in the buffer area, there will be a decrease of built upon area on the lot from all the improvements. Government exhibit number 7 is considerations. The hardship is not a result of actions taken by the applicant since the existing home was built prior to the buffer requirements. The requested variance meets the intent of the ordinance to preserve water quality since there will be a decrease of impervious within the 100-foot buffer area. The proposed addition does not encroach into the required 50-foot state watershed buffer. The requested variance is in keeping with neighborhood character because 6 other variances have been granted on Riverhaven Drive for the watershed buffer. And on the aerial photo in red are where the areas are where the other variances were granted. The requested upholds public safety because the applicant has agreed to conditions to ensure compliance with the floodplain ordinance. So exhibit number 8 goes into those staff recommended conditions for compliance with the floodplain ordinance. Mecklenburg County Water Quality staff supports the requested variance with the proposed conditions, and the applicant has agreed to these conditions. And government exhibit number 9 is a photo of the property. And the house is kind of obscured in this photo. This is what it looks like currently. There's kind of some shrubbery in front, but the house is behind those bushes. So that's my presentation if you have any questions.
All right. Max, Max, is there anybody signed up to speak in opposition?
No, signed up to speak in opposition to this case.
Okay. This case should be moved to the regular agenda. Okay, hearing nothing, is there any questions for staff?
I have one question. Conditions that the development permit must be issued before the construction can start. Is there going to be a problem getting that floodplain development permit, Lisa?
No, there should not be any problem getting that permit as long as they're compliant with the floodplain ordinance.
Okay, thank you.
Any other questions for staff? Or motion?
This is Dryden. I make a motion to approve this variance based on the conditions that are in the finding of facts.
Okay, thank you. Is there a second?
Welch, I'll second.
We have a motion by Mrs. Dryden, a second by Mr. Welch to approve the variance with the conditions that are that were presented. Take a roll call vote. Dryden,
Yes.
Mr. Welch,
Yes.
Ms. Long,
Yes.
Mr. Floyd,
Yes.
Anderson, yes. So approved unanimously. The fact and conclusions of, I didn't see anything. Thomas, do you have any revisions that you've noticed? Okay. Is there a motion to approve the findings of fact and conclusions of law?
Mr. Welch, I make a motion we approve findings of fact.
Thank you, Mr. Welch. Is there
Dryden
a second?
seconds.
We have a motion by Mr. Welch, a second by Mrs. Dryden to approve the findings of fact and conclusions of law as presented. Take a vote. Mr. Welch,
Yes.
Mrs. Dryden,
Dryden, yes.
Ms. Long,
Long, yes.
Yes.
Sanderson, yes. Okay, our next case, is case 2020-134. Go ahead, Lisa.
Okay. This is a commercial floor area ratio variance. The applicant is requesting a 0.6 floor area ratio variance to allow a building addition and adaptive reuse of an existing building. And since it does involve floor area ratios, which is something we don't see that often, I broke down all the floor area ratios on the third page of your findings. So if you have questions about how any of those numbers were calculated, it kind of breaks it down for you on that page. So I'll give you a few minutes to look over your findings.
Go ahead, Lisa. You can go ahead and walk us through this. Lisa, you're muted. Lisa?
All right, Lisa's coming in my office. Her computer locked up, so she's walking over here right now.
Okay. When she's ready, we can go ahead and start the presentation.
Max, would you make Shad host?
Yes, I'll do that. Okay, Chad should be host.
I need just a minute. I'm going to pull up the presentation in Shad's office. All right. Exhibit number 1 is a vicinity map of the subject property. Exhibit number 2 is the zoning map of the property. The property is zone B1 neighborhood business. Exhibit number 3 is an aerial map of the property. Exhibit number 4 is a close-up aerial map of the property. And exhibit number 5 is background. The property was subdivided in 1938, and the plat shows the Blair Hill Road right-of-way running through the original lots. So you can see the properties highlighted in yellow on the right are the original configuration of the lots. And then if you follow the red arrow over to that map, that's how the lot looks now, and you can see that right-of-way running through with the lot beside it. The property has since been reconfigured, and in 1985, a hotel was built on the property. Government exhibit number 6 is the variance request. Existing building has a floor area ratio of 0.87 and predates current zoning ordinance requirements for non-residential buildings in the B1 zoning district, which allow a maximum floor area of 0.5. The applicant would like to convert the building to a single room occupancy residence that will serve the homeless community. In order to convert the building, a 6,500 square foot addition is needed to house support services, which would bring the floor area ratio up to about 1.02, which can then be rounded up to 1.10. The applicant is requesting a 0.64 area ratio variance to allow the building addition and adaptive reuse of the building. Staff supports the requested variance. Government exhibit number 7 is considerations. The applicant has exhausted other options. The applicant owns the property to the south of Blair Hill Road right-of-way, and they wanted to combine that with the subject property to allow a greater floor area ratio. In order to combine those properties, the Blair Hill Road right-of-way would need to be abandoned. The applicant pursued that right-of-way abandonment for the Blair Hill Road right-of-way, but it was unable to do so because of another property owner abutting the right-of-way that didn't consent. There's also a 1985 approved conditional rezoning plan for the property to the south that specifies that the Blair Hill Road right-of-way would be abandoned. That plan also specified that the property was to be used in conjunction with the subject property. If the right-of-way were able to be abandoned, the combination of the two properties would result in a compliant floor area ratio of 0.48. And government exhibit number 8 is photos of the property. So on the left, you can see the parking area, and you're looking towards the Blair Hill Road right-of-way and the side of the building. And then on the right is the front of the building. And that's my presentation if you have any questions.
Okay. Max, did anybody sign up to speak in opposition to this?
No one has registered to speak in opposition to this.
Okay. Does the board have any reason to believe that, or have any reason they want to move this to the regular agenda? All right. Are there any questions for staff?
Mr.
Before
Chair.
be myself, Dryden, Mr. Welch, and Mr. Wilson. So.
Okay.
Go ahead.
This is Ms. Dryden. I vote to approve this zoning request. It looks like the applicant has tried to get the land that would, I don't understand why, I don't have any background. I don't know why abandonment was not, not approved by all the people, but I vote to approve this request.
Okay.
I second.
We have a motion by Mrs. Dryden, a second by Mr. Wolf. Approve the. We'll take a roll call vote. Mrs. Dryden.
Yes.
Mr. Wilson.
Yes. Yes.
Mr. Welch.
Yes.
Ms. Long.
Yes.
Sanderson, yes. Let's look at the findings of fact and conclusions of law. On number 4, it should be through the property, not up the property. So change the word to through. And then on number 14, there's an extra A in that sentence. It needs to be removed. That was on the findings of fact section. Any other revisions that need to be made?
Mr. Chair,
Yes, Mr. Powers.
one thing I was going to ask the members of the board is that I noticed there was a lot of footnotes, references to the floor area calculations at the very bottom on the conclusions of law. I didn't know whether or not you wanted to include those floor area calculations in the actual findings of fact, instead of kind of cross-referencing them as a footnote.
I don't know whether the board.
You're breaking up, sir.
I said, are there any other suggestions from the board? I didn't have a problem with them. I thought it was good information to have, but I can see if we include it, it just may be extraneous. Any other thoughts from the board members?
I think it was good information for us. I don't know that it needs to be in the conclusions of law. I think just be that it was good information for me to have, but I don't believe it needs to be in there. I agree with Mr. Powers.
Then let's go ahead and strike that information.
Mr. Chair, let me clarify.
Powers.
I was not asking you to remove the information as a footnote. I was asking you to relocate it to the actual findings of fact.
Okay.
So you would add that in one of your many findings as an additional number. That was my intent.
Five then. I don't think we a number for it. I think we just included as no part of number 25, if I'm not mistaken.
If Mr. Chair, if you're willing to add this as another finding of fact, I think you can just go ahead and delegate that authority to me, and then I'll just use the exact language of the floor area calculations as that finding of fact.
That sounds like an even better plan, Thomas. Let's do that. So is there a motion for approving of the findings of fact and conclusions of law to allow Mr. Powers to make that revision in the other revisions that we've discussed?
I make a motion to accept with the revisions noted.
I second.
We have a motion by Mrs. Dryden, a second by Ms. Long to approve the findings of fact and conclusions of law with the revisions to be made by Mr. Power and the ones that have been noted. We'll take a roll call vote. Mrs. Dryden.
Yes.
Ms. Long.
Long, yes.
Mr. Welch.
Welch, yes.
Mr. Wilson.
Yes.
So that concludes our recommendation agenda items. We have two agenda items. If it would be all right with everybody, if we could take a 10-minute break and reconvene at 11 o'clock. Would that be okay?
Thank you very much.
And we will reconvene. We'll take a 10-minute recess and we'll at 11 o'clock.
Hello? Hello?
Leave me alone. And they have them on mute. I don't understand.
So they might, that's what I'm saying, they got the information, they just probably get in. If they do get something they want to say, then when it comes presentation, whoever has something to say, it comes out. With anybody who over there is pretty much like,
Well, she the one took that sign down.
yeah, but you still ain't got no argument about nothing. If somebody over there, they get moved
Excuse me, I have a call-in user on the phone. Could you your name and which case you're here for? Is it Hall Avenue or Nance Road?
Yes.
Yes,
My
great.
name is Robin.
Miss Fox?
Yes.
Oh, okay, great. Okay, you're calling. So your case is the last case. There's one more case before yours.
Yeah.
There's one more case before yours.
Is it any reason why you skipped it?
Several people have called to ask it, so it's been moved to the regular agenda.
Okay, so we will hear it today, right?
That's correct. I'm sorry, I didn't realize that you hadn't received an updated agenda. I apologize for that. That's my.
Okay. All right, thank you.
Thank you. There's a Harrison Reed on the call. Are you here for the Hall Avenue or Nance Road case?
Henderson Reed.
Oh, Henderson. I'm sorry about that. Are you here for the Hall Avenue or
Nance Road.
Nance Road? Thank you. And there's before that one.
All right, thank you.
Thanks. And there's also Sandra Mickens. Could you state which case you're here for?
Okay.
If you can hear me.
Can you hear me?
Yes, I can.
Yes. I'm here for case number 2020-124 in opposition.
All right. They will call. So it's on what we call the regular agenda. There'll be a chance for opposition to speak. So I will unmute your microphone when that time comes. There's one more case before the Nance Road case is heard, which is case 2020-124.
Okay.
All right. I appreciate that. Thank you.
Sure.
Oh, really? You have a lot of opposition on that one?
Yeah, I spoke with, a couple people. It seems like there's.
Yeah.
So I think they're, maybe.
Yeah.
Max, can you hear me or see me?
I can hear you, and I can see you, but it's very, very blurry.
Okay, maybe I'll just turn off my video. All right, can you give screen sharing privileges to me?
Oh, yeah.
Wait, Chad.
Okay, you should be presenter now.
Is everybody back? See Mrs. Dryden, Mr. Welch, Ms. Long, Mr. Wilson. I don't see Mr. Floyd back yet. He might not have his video on. Is this, okay, thank you. Is this the case that we continued from last month?
This is the case that was continued from last month, yes.
Can you tell me who was sitting on the, do we need to have the same people sit on the case today as we had last month if possible or not? I guess that's a Thomas question. I don't know if Thomas is back yet.
Well, while we're at it, we had you, Mr. Brown, Ms. Dryden, Mr. Wilson, and Mr. Floyd.
Okay, so we'll need somebody, Mr. Welch. We'll go ahead and have Mr. Welch sit on this. Mr. Brown's place, so we have 5. Is Thomas back? He just doesn't have his video on and he's muted. Ms. Tree?
I am.
Okay.
And Jill is here too. Mr. Sanderson, now that Terry, I think I heard that Terry Brown was present and heard this case previously. He's no longer on the board. My question is, have all of you been given an opportunity to review information from the last meeting on this case?
Max, didn't you send out that information from the last month?
Yes, the video of the hearing was sent out before this meeting. I believe Ms. Long was in attendance at the meeting, if that helps, but I don't believe Mr. Welch was.
Okay, Mr. Welch, did you have a chance to review it?
Unfortunately, I have not.
Okay, then Ms. Long, you want to take Mr. Brown's place?
Sure. Yeah.
Okay. Since you did sit in on the meeting, you didn't participate as a board member, so then we'll have.
That works great. Thank you.
Okay, thank you, Terry. So we'll have myself, Sanderson, we'll have Mrs. Dryden, Mr. Wilson, Mr. Floyd, and Ms. Long will be on case 2020-099. I'd like to have Thomas back to make sure, as well as Jill and Terry, to make sure everybody's here before we restart this case. I don't know how to get a hold of Thomas. He still shows up, so.
I'll text him.
I'm on the actual meeting.
Okay, thank you, Thomas. So we're gonna have Ms. Long, since she sat in, she was here for the last meeting but did not participate as a board member on this case. So she's going to take Mr. Brown's spot on the board for this case, since it is continuance from last board meeting. So with that, will that suffice? I know Teresa, that's okay for her. Is that fine for you, Mr. Powers?
That is fine.
Thank you. And go ahead, Lisa. Let's go ahead and start this.
Okay, the next case is 2020-99. It's a residential accessory rear yard variance. The applicant is requesting a variance from the 25% encroachment allowance to allow a deck to encroach 80% into the required rear yard. And I'll give you a minute to look over your findings. There's only a few slight tweaks with the new request.
Max, the findings of fact and conclusions of law that you sent me, there's a figure that sits on top of the top 4 or 5 items.
Oh, is there a, yeah, I'm sorry that there's an issue. Let me send a PDF version.
Okay.
I'll send that out to everyone. Okay, a PDF version of the findings of fact has been sent out to the first.
Okay, Lisa, you can go ahead and start.
Okay, Exhibit 1 is the vicinity map of the property. Exhibit 2 is a zoning map of the property. The property is zoned R22 MF multifamily. Exhibit number 3 is an aerial map of the property. And exhibit number 4 is a close-up aerial map. Exhibit number 5 is background. In 2020, a deck was constructed on the rear of the home. Exhibit number 6, a code enforcement officer made a field observation of the new deck construction and issued a notice of violation because no permit was obtained and the size of the structure exceeded the size permitted for zoning. Exhibit number 7 is the original variance request. The applicant exceeded the size of their previous compliant deck that can be seen on a 2010 survey to approximately 4.4 feet from the rear property line. Exhibit number 8 is the amended variance request. The applicant has changed their request to allow an 80% encroachment into the 20-foot rear yard, and now they request a 17.5% variance from the 25% rear yard to allow the upper store of the deck to encroach 8.5 feet. So that's 3.5 more than is allowed with the 25% encroachment allowance. And they propose to detach the first story of the deck so that it would not be subject to a variance. It would not require a variance, and it can be 3 feet from the side and rear yard. In order to do that, they have to make sure the deck is not attached to either the home or the top story of the deck. Exhibit number 9 is considerations. Staff finds that the requested modification still does not meet the zoning ordinance requirements in order to be granted. The hardship is caused by the applicant. The previous deck was compliant with zoning. The hardship's not peculiar to the property. The hardship results from personal circumstances and conditions common to the neighborhood. The 20-foot rear yard and maximum depth and deck encroachment of 5 feet is shared by all single-family dwellings in the R22 MF district. The requested variance is easily detectable because of the topography of the area, and the requested variance is not in keeping with neighborhood character. Exhibit number 10 is the consideration of the topography. So it shows how you can see the deck very well from the neighboring property. Government exhibit number 11 is a photo of the subject property. And we also have the applicant on the WebEx meeting, and they may want to speak, but that is my presentation if you have any questions for me.
All right, thank you, Lisa. Are there any questions for staff from the board?
Lisa, can you clarify for me how this second request differs from the first request? As far as the deck, has not changed, or is it changed?
Yes, let me go back to that slide. Okay, so in their first request, they just wanted to maintain what they built without the permit in 2020. That 2-story deck where both floors were 4.4 feet from the rear property line. So you can see that on slide 7.
Right.
And then now they're modifying their request. They propose to detach the bottom floor of the deck because if they detach it, detached accessory structures can be 3 feet from the side and rear property lines. So if they do that, then they wouldn't need a variance for the bottom story. And so then it just can't be attached to the top floor or the home. And they're shortening the depth of the top story to 8.5 feet in depth. So it would still exceed the allowed 5 feet by 3.5 feet, but it's shorter than their original request.
Thank you for that clarification.
Mm-hmm.
But the first story of the deck stays the same dimension. It's just that it's no longer attached to the structure or the deck above, correct?
The applicant just specified that they were going to detach it, but we don't have any plans of of what exactly they're gonna do, so I
As
don't
long
know
as they
if
stay
it's-
within the required, as long as they stay within that required 3 foot, I guess, setback from that deck, correct? Then they
Yes.
don't need a variance.
Yeah.
Okay. Any other questions for staff?
So Lisa, is if I'm looking at the findings and facts of law correctly, staff still is not approving this variance, am I correct?
Correct. Staff does not feel that it meets the criteria in the ordinance for granting a variance because hardship was created by the applicant. The previous deck was compliant and they've built one that's not compliant. So they're able to be in compliance.
I think there were people that spoke against this last time. Is there still people objecting to this variance request?
I've not received any feedback from anyone that previously objected or any new objections to the request.
And I see the kind of following up on Ms. Dryden's question. I mean, I get that the deck is size of the top is decreasing, but how much is it decreasing?
All right. Give me 1 second here. So I believe previously it was 16 feet in depth. And then now it's going to be 8.5 feet in depth.
Okay, so it's getting cut in half, basically.
Yes.
Lisa, can you show the picture again of the rear with the deck again on the house? The topography picture?
Yes.
Thank you.
Looking at the picture, even if you cut that deck in half, it's still going to be basically overlooking the neighbor's yard. Maybe not as correct. I mean, if I'm looking at that right.
Yes. And
Yes, but I mean, the 5 foot deck did the same thing.
Right, correct. So now it's 8 feet. All right, what my concern is, they say, I mean, the homeowner is telling us that they're going to detach the lower deck, but if we approve this variance, what guarantee do we have that they do detach that lower deck? Plans or any? I'm confused. I don't understand how you detach, because my understanding is that if you detach the lower deck, the upper deck can't be attached to that lower deck and still be attached to the house. Can you explain that part to me, Lisa? What it means to be a detached deck?
so in order to be detached, it couldn't share any of the support beams of the top deck, and it couldn't be attached to the home. So it would have to be freestanding on its own. And I notified the applicant of that. She said she'd still wish to detach it. So I'm not sure what that looks like, because it wouldn't be allowed to share, any structural supports or be attached to the house. So I'm just not sure how that's going to be accomplished.
And is there any definition for the separation that's required to meet the detached requirement, or is it just could be as small as an inch or half an inch, if depending upon? I mean, I'm just trying to figure out, is there any definition to the separation that's required for a detached?
I might ask Shad to weigh in on this. I believe it might be a foot from the home.
Now, if they detach it, I'm trying to remember if there was a door on the lower level or not, and I don't recall. I mean, it would have to be detached. So if there was a door on the lower level, that it doesn't, you can't do, 3 inches and you just step over and you're still functions as it's attached to the house. So, I mean, it's something we'd have to evaluate. They haven't supplied or presented any plans to us as to how they're proposing to separate the deck at this time. So we would just have to evaluate that when they present it. But right now, there still is an active notice of violation. So if it's not removed, then we would proceed with that action.
Are there any other questions for the so that we can get the applicant involved and let them make their presentation and update us on what their presentation is? Okay. Ms. Murray, I see you're on in the meeting, and Max, you've made her a part of a presenter or a panelist. Is that correct?
That's correct. Ms. Murray should be able to mute and unmute herself.
Okay, Ms. Murray, before you start, tell the truth, the whole truth, and nothing but the truth in the matter at hand.
Myself. There we go. Yes, I do.
All right, go ahead and make your presentation.
Okay, well,
now.
the first point that I'd like to make, which I corrected last time, and it's really rather important to me, and I do state this under oath, that deck was built in 2019, early 2019. I purchased that property in January of 2020. So the deck was already there. I had no reason to believe that it was not compliant at the time I bought the property. So that's the first thing I just want to say. I do understand the protests that my neighbors had, and I discussed with them, and we went over it. And they're both medical professionals, so they're not able to be here today. I did submit an email from them, which stated that they no longer had a problem with my bringing it back to adding the 3.5 feet to the 5-foot deck that was originally there. The bottom deck is very easily separated from the top deck. The 8.5, because there's a beam there, but you just cut right around it and cut the base off. It's not attached in any kind of structural way. The bottom deck cannot be seen from the street or from anybody's around there. So I really don't fully understand what the problem is on that one. That's pretty much, it's just, this would give, by adding the 3.5 feet, it would actually allow us to have something that is more than just a landing outside of the house. There is no door down below. You have to have a landing anyway to get downstairs or go out of the house and go all the way around. I did appreciate the board's allowing me to go back and make these adjustments to the original request. And that's basically it. Do you have any questions?
All right, thank you, Ms. Murray. Is there any questions for Mrs. Murray from the board?
Ms. Murray.
Yes.
This is Shad. I've got a question. I'm looking at your applicant exhibit number 1.
Mm-hmm.
With the 8.5 feet, you're saying that would allow that support tower to remain that's just to the right of the steps, if I'm looking at that picture to the right.
You can't really see it. There's one right where that board goes down, there's a support underneath there. So, I mean, we would probably have to adjust the supports. Unfortunately, the deck there was never a building permit pulled for it, so I'm not at all sure that it's in compliance anyway. So that will have to be done as well. I would follow all of the necessary zoning and building codes in order to make this right.
Okay. Thanks.
You're welcome.
Can I just ask, why do we and I'm not sure if this is a question for the applicant or for staff, but why do we have a dispute about when the house was purchased and whether or not the condition was there at the time she purchased it?
There is, one of the findings is that if it's not dated by the applicant, then that helps with granting a variance. So if the expansion was done prior to the purchase, then it kind of helps the argument to grant the variance, even if they were aware of a situation that would even require a variance.
Yeah, I understand the significance of the issue. What I'm asking is, she says she bought the house in 2020 and this was constructed in 1999, and it's
2019.
I mean, it's, yeah, sorry, 2019. And I think the proposed findings of fact have something different.
I don't know why it says that. I corrected it at the last meeting. That's what I put on my original application. I do not know why that mistake is in there.
It could be that they had not updated the system when last I looked, so. Since it was so recently purchased in 2020, so I just am not sure.
Yeah, it says here in the findings of fact that there was a 5-foot deck as of the survey of March 29, 2010. And then the survey of October 6, 2020 shows the current deck and its current configuration, but it doesn't say anything else about when it was done. So based upon that fact, Shad or Lisa, with Mr. Murray buying the property in 2020 and then testifying under oath that the deck was there prior to her acquisition, would that change staff's decision, or would that?
I think that would meet the one finding that the hardship was not created by the applicant. I still think that there's other findings that it would not be able to meet since the previous deck was in compliance.
Well, the deck from 2010 was in compliance.
Mm-hmm. Yeah.
But the property owner had nothing to do with that deck. As far as she knew, that deck didn't exist.
That is correct.
Yeah, I just can't verify that because I guess when I was doing my research, the system had not been updated yet. If the purchase was, timed like that. So.
Mr. Chair.
Yes, Mr. Powers.
If I may weigh in on this for the board, I think the aspect and the issue of ownership of the property, whether it's in 2019 or 2020, as staff has alluded to, goes to the aspect of whether the hardship was caused by the applicant or not. But again, because you're considering a variance, there are 4 actual components for the variance. So even if you were to modify the actual findings to account for this one fact, the applicant is still obligated to show the other 3 as part of the evidentiary aspect for you to consider whether or not they are entitled to a variance. Again, that's just one aspect, but that is not all of the factors for your consideration to determine to grant a variance.
Correct. Thank you, Mr. Powers.
Again, if I could speak for 1 minute. In my original application, we did address the fact that the property, as you can see, if you look at the zoning map there, is considerably smaller. The 3 properties, mine, the one next to it, and the one next to that one, are very much smaller than the other properties in that same area, so that the 20-foot setback really limits what we can do in our backyards. In addition, there is extensive flooding that occurs on these lots, so that the downstairs is really very much not usable. That's why we have a raised lower deck down there. And it was just an attempt to make a space that someone could come outside and use and sit comfortably, and to add to the quality of the home in the same way that other homes in the area have accessible outdoor space that they can use. So that was, and I can't remember what the other two conditions are, but I think I addressed those as well in the initial application.
Okay, thank you, Mrs. Murray. Thank you, Mr. Powers. Any other questions from the board for the applicant?
I'm still confused about the detachment piece for the lower deck.
Okay, if you look at that picture there, you see how it's actually not, it's just next to it. It's not even attached to the house at all. So what would have to be done would be that where the beams, the supports that go down on the deck come down, you would just cut around that so that it's not touching, or it's, you know, a foot around supporting that. And the lower deck then becomes completely detached from the house. You cut it away so that it doesn't touch the house. You go 1 foot in that way. You make sure that it didn't touch the supports going around for the upper deck, and it would meet your requirements, I believe.
Okay, thank you. Any other questions from the board? All right, hearing none, staff, Lisa and Shad, you your final comments?
No final comments.
All right, Mrs. Murray, we'll give you the last word.
Mr. Sanderson,
yes.
The applicant said that she had an email from the property owners below her that she had talked to. Do we have access to that email?
I did send it to you.
That would be a Lisa or Max question.
The applicant did send it to me and Max, and it was a forwarded email from the neighbor that she was okay with it. And we said, you know, if she could get the neighbor to speak at the meeting to share her support, that would be great, because it would be hearsay evidence. But there was a letter, yes.
Thank you.
Okay. All right, Mrs. Murray, you have the final word then.
Okay, well, I just want to thank you all for your consideration, and I do hope that this will be doable. But even if it's not, I am grateful for the conversation that went on between me and you, and between me and my neighbors. And I leave it up to you all. Thank you.
All right, thank you. We'll go ahead and close the hearing, and we'll begin our deliberations. During deliberations, only the board members and or Mr. Powers may participate. And if we need to have it, if the board members have any questions, then we can reopen the hearing and get those questions answered. So let's see. Let's go ahead and start with Mrs. Dryden, because that's how I have them listed on my piece of paper, who's sitting on this case.
Okay. I looked back over the notes that I took when we had this meeting in December, and we were very concerned about the encroachment and that there was no permit hold to build this deck. And I'm looking at how much they're pulling it back, as someone mentioned, about half. So I don't know. I hear what other people think. I'm still worried about even the 8 foot, because of the topography of the land. There were a lot of people who talked about this. I know we had a similar case, not this one, and I know, but those people pulled the whole thing because they said they were going to detach the whole deck. So this is all there. This one, they're saying they're going to detach the lower deck and shorten the upper deck. I'm still concerned because zoning has still said they don't like it. So I'm open to other thoughts.
Yes, that is a question. I guess I'm getting ready to reopen the case. I have a question for Shad. Reopening the hearing. Shad, if both decks were detached from the house, would there be any reason for a need for a variance?
Well, I don't know how you could detach the upper one safely with a door that would open up onto that.
Well, the door opens in.
But if you're
based upon the picture, based upon applicant exhibit number 1, the picture on the right looks like the door opens in.
well, but if the deck is functioning as part where you can just walk out the door onto the deck.
That's what that goes back to my definition. That's why it goes back to my question about what's the requirement for required dimension for a separation.
Well, I would say it couldn't function as, walk out the door onto the deck.
Mr. Powers, yes.
As it's attached.
Shad, in regards to this, I think maybe the chair is asking if you had maybe a landing where you step out the door and immediately proceeded down the steps, and then the rest of the deck would then be detached from the entire house, and maybe you could have some steps on a new detached 2-story deck that would be detached from the house. Mr. Chair, is that kind of what you were thinking?
I'm trying to think. I mean, if I have yet to figure. I mean, if there has to be a landing, I agree with that. But yeah, like you said, if there was a separation between that landing, whatever that, I'm trying to figure out if there's a dimension that staff uses to define that it's separated. If you can slide a piece of paper through it the whole way and show that there's no connections, or if it has to be 6 inches, 1 foot, 3 feet.
We would have to see it. I don't see how they could functionally separate the upper deck and us to technically call it separate unless you're coming down the steps and then having to walk back up steps to the deck that is separated by like 4 or 5 feet. Because honestly, I don't think Mecklenburg County building standards folks would allow for something that they could walk out the door and jump over a foot separation to get onto the deck.
Okay. All right. Well, that answers my question then. Okay. All right, then we'll go ahead and close. Is there any other questions before I close the hearing again for staff? All right, let's go ahead and close the hearing and get back to deliberation.
I do have Shad, the homeowner is proposing for the lower deck, actually cutting out concrete in so many feet away from those posts. Is that acceptable for separation from the house or deck?
I mean, obviously we'd have to see that, but that does sound more reasonable since there's no access into the house on that lower level. So it would you still have to, come down those steps and then access the lower deck probably by a step or something. So that sounds more reasonable to me. But we would just have to see the proposal.
Okay, thank
you. All right, then let's go close the hearing again. So let's go to Mr. Wilson. Thoughts?
Yeah. So my thoughts are, I am leaning to approving a variant, but also I'm wondering if it's possible that we, I guess, move this to the next meeting and probably encourage the applicant to have on the next meeting their architect so he or she can clearly explain to us and we can visualize how the new deck would look. But I think just hearing from Mrs. Dryden and even you, Mr. Chair, and I'm even trying to visualize it myself on how it would look. I see what the applicant is trying to do, but it is hard to visualize it from the two photos we have here. Like I said, I am leaning towards approving it, but at the same time, I'm wondering if we can just get a better visual of how it would look.
Well, we need to remember the 4 criteria that need to be met are an unnecessary hardship resulting from a strict application, a hardship that results from conditions that are peculiar to the property, whether it be location, size, or topography, a hardship that results from actions taken by the applicant or the property owner, and that the spirit, purpose, and intent of the zoning ordinance, and that public safety is not secure, is secured and substantial justice is achieved. So that's what those are the criteria we have to meet when we review these cases.
Yeah, and I remember Lisa saying that if the applicant, based upon what the applicant is suggesting, it may meet some of that criteria. Am I correct? I don't know if you could answer that, Mr. Chairman. I would hate for us to go back into session, but based upon what I remember,
it may meet it. May meet the criteria if that's how you view it. I mean, I haven't made up my mind yet, so I don't know. But it may meet the criteria, but we have to meet all 4. It's not meet 1, 2, or 3 of them. You have to meet all 4 to grant the variance or to.
Okay.
Well, I see, the hardship results from actions taken by the applicant. If you go back to her argument that she bought the property, the deck was already there, then that might be questionable, but the hardship does not result from conditions that are peculiar to the property, because all the lots on that property share that same 5-foot little porch. And so and the topography is the same for all of the houses along that road. So that to me stays the same. It doesn't result from conditions that are peculiar to this property. It is the variance is not consistent with the buffers. And I don't see that it would be an unnecessary hardship because she's going to have to take the deck down. She's going to do something because it's out of compliance. And that's out of our hands. But I'm just, but I'm like Mr. Wilson, I would like to say yes to this. But I'm just conflicted because once we say yes, then I can see if you look at this picture, photo 2, that she's taken of her lower deck, the house next door has one of those big long decks too. And you can't tell from that how long it is, but then I don't know.
Okay, Mr. Floyd. You're muted. Okay.
Yeah, sorry. I'll say when we first heard this case, I was definitely against granting the variance. I appreciate the fact that the applicant has gone back to the neighbors and has come back with a more reasonable proposal. But I'm just having trouble getting to the point where I see evidence that supports all four factors that we're supposed to consider. I mean, it's not, do we like what they're doing? It's, is this an unnecessary hardship? I mean, what we're talking about is a 5-foot landing versus an 8.5-foot wide landing. I'm not sure I see that as an unnecessary hardship, that you're 3.5 feet less. I can make an argument that the hardship results from conditions peculiar to the property. The applicant did provide testimony that the size of the lot here is smaller than the other ones in the area. I think we've got enough evidence to say the hardship did not result from actions taken by the applicant. Is the requested variance consistent with the spirit and purpose of the ordinance? I don't know. It's that first and fourth factor where I'm just going, I don't know if I saw anything to say that those two things were met. And without that, I think I have an obligation to vote to deny the variance. But I mean, it is certainly one where I'm sitting here trying to play devil's advocate to come up with a way to reasonably find that these factors have been met, and I'm just struggling to do it.
Okay. Ms. Long?
I would agree with what Mr. Floyd just said. You're talking about a 3.5-foot difference. And the bottom deck, I don't even think is a factor here because they can certainly detach it and go around the support poles. But I'm struggling as well to approve it. I tend to agree with staff's recommendation.
Yeah, I'm with you and Mr. Floyd. I think that meeting the four criteria is an extreme reach for me right now. And I wish there was a way to make it happen and figure it out, but short of separating both decks from the house, which staff has said is not really practical either from their standpoint or from building code standpoint, which I understand. I don't know how we can get there. So Thomas, have a question for you. Staff in the finds of excuse me, finds of fact and conclusions of law, staff finds that the variance does not meet the criteria for granting the variance. So if we have a motion, we either need to have a motion to uphold staff's decision or a motion to approve the variance. Is that correct?
Since staff is only making a recommendation to this board, your actual motion will need to be either A, to grant a variance or to deny the variance request.
Okay. Any more deliberations or discussions we want to have with the board? Or is the board ready to make a motion one way or the other? I don't know if any additional information continuing it to get additional information from the applicant is going to answer and solve any of the questions concerning the hardship criteria that we have to meet. So that's my thought. If you all want to have that, discuss that, we can, but we've already continued it once to get the additional information, and we appreciate Mrs. Murray providing that additional information to us this month. So waiting to hear from the board how you want to proceed. Either a motion.
Mr. Chairman, I agree with you. I think that we should proceed to a vote.
I agree. We should proceed to a vote.
I agree as well.
All right, well, as the chair, I cannot make a motion, so. That's probably the only positive thing about being the chair, is that I don't have to get into the motion part of it, but.
Motion to deny the variance.
Dryden, that.
All right, we have a motion from Mr. Floyd and a second by Mrs. Dryden to deny the variance. We'll take a roll call vote. Floyd,
Yes.
that's a yes vote to deny. Mrs. Dryden,
A yes vote to deny.
Mr. Wilson,
No vote to deny.
okay, and Ms. Long,
That'd be a yes vote to deny.
and Sanderson, that would be a yes vote to deny. So the variance is denied 4-1. All right, let's look at the findings of fact and conclusions of law. I didn't see anything that needed to be changed. So,
The only thing, do we want to, because of this issue of when she bought the property and that the deck was already there, do we need to make a note of that anywhere in this or not? I mean, I'm just asking.
Mr. Chair and Ms. Dryden, I think that we should actually make a note of that. I would recommend that number 9 be modified to say, per the applicant's testimony, in 2019, the deck was expanded.
okay. Then do we need to, based upon that, should we change conclusion of law number 3 that the hardship results from actions not taken by the applicant or the property owner? Or leave it as?
One moment. I think that's one issue as well, but I think there's another aspect of this that I would like to address with the board. If you can just give me one moment. I think based on the information that the board has discussed and talked about, I would recommend that this board also add some additional findings of fact addressing the peculiarity of the property and the aspect that the essential character of the neighborhood. There was some testimony that was provided about how this property may not have been peculiar, and I think that would be something to do about, put into the actual findings about that, as also to the character of the neighborhood. I think there were some aspects as well that was talked about in this testimony and discussed by this board.
I mean, I'll just say for me, the decision came down to, I don't think there's an unnecessary hardship. So, I mean, again, as I said during deliberations, I think you could make a reasonable argument that the size of the property in comparison to the other properties in the area, could be a condition peculiar to that property. But it's that first factor that, for me, is really the deciding one.
Mr. Powers, isn't that in number 18, it says the hardship is not peculiar to the property and results from personal circumstances? I mean, doesn't that comment to the neighborhood? Isn't that for what we're talking about?
I think it does, but I think if you want to strengthen that a little bit more, that will be also a part of my recommendation. I think that information is okay, but I think that based on some of the discussion, I would recommend that you improve or add to it as well. I do think that Mr. Floyd's comment about the hardship not being present may also need to be discussed by this board as well, because there's opinions as to whether a hardship does or does not exist. So I think the board should, have a discussion about that and land on a definitive standpoint that there is or is not a hardship in addition to my other recommendation.
Well, I would say it's not a hardship because the applicant, based on the notice of violation for the deck construction, is going to have to take this down regardless. Whether we approve this or whether we disapprove this, they're going to have to remove that deck. So I don't see that it's an unnecessary hardship for us to deny this. Could you tell me? Okay, go ahead.
So I will say that to Mr. Floyd's point about the hardship issue, if the board is wanting to look at this, the hardship, that information about the hardship possibly being in existence or the construction of the deck being a violation prior to the owner purchasing the property may fall under a particular conclusion of law like number 3, saying that it was not from the applicant directly. But you could also then say, as a whole, as Mr. Floyd alluded to, that the overall hardship does not result from the strict application of the ordinance, would still allow you to have a position of the applicant did not create the circumstances for the deck being built that way, but the applicant can still utilize the deck in compliance with the ordinance in this regard. So I think those are ways you can kind of reconcile it if you want to take that approach. But I think it would be good to just kind of show that. Like number 16 talks about the unnecessary hardship does not result from strict application of the ordinance. That goes into, as I said before, kind of bringing together Mr. Floyd's point with some of the other commentary before the board.
May I make a motion, board, to say that we allow Mr. Powers to beef up number 18 and reconcile number 16 as we've discussed?
Ms. Dryden,
yes.
I would ask that you do not do that, only because typically if I am trying to make an edit to any of your proposed findings of fact, I like to generally keep it very simplistic as a check the box situation. Using the example from the last one of our previous decisions, it was, again, let me relocate, information from one part of the finding of fact into an actual numbered finding of fact. So it's very simplistic. If I am making an edit that is incorporating all of your actual thoughts into it, I would be very hesitant to do it simply because I'm unsure that all 5 members of the board would actually agree with that point at the way I am drafting it. So if you all have some general thoughts and say, this is what we would like to see incorporated, and everybody says, I like that point, Thomas, take that point and make it a new finding of fact, or use that to incorporate into an existing one. That's different because you're telling me what you want. But if you ask me to draft it from scratch, I'm going to be very hesitant to do that offline.
I understand that. Thank you.
So do we want to?
I just put some proposed language in the chat for a revision to paragraph 16.
that item.
I do as well.
Thank you. I like that very much.
Mr. Floyd?
Yes.
Yeah, if I may make one small edit to your proposed language, where you have, and the applicant will be required to incur expenses associated with the renovations. If we could modify that to just say, and the applicant will be required to renovate the deck, regardless of the variance being granted or denied, because
That's
the
fine.
expense.
Yeah,
Okay.
understood. I get the thought there.
Thank you, sir.
I agree with that revision.
For number 18, did we say the hardship is not peculiar to the due to the same topography and drainage conditions exist on adjacent properties within the neighborhood, or something to that effect?
My thought, because all the houses along, according to what Lisa told us, that all the houses share that same topography and condition.
To ensure that I am recording the language as well as Max, could someone please repeat the sentence for number 18?
The hardship is not peculiar to the property due to similar topography and drainage issues on adjacent properties and throughout the neighborhood.
All right, just to make sure I have it correctly written, the hardship is not peculiar to the property due to similar topography and drainage issues on the property and in the neighborhood.
Yes.
Do we still also want to keep the language and results from personal circumstances and conditions common to the neighborhood? Or do we want to delete some of that?
I would probably keep it.
Okay, that's fine. I do at least make sure you are aware of that before we move on.
Are there any other ones we need to revise?
I think just conclusion of law 3 needs to be, I think we mentioned that before, but just, that's the one where I think the applicant, it is in favor of the applicant. It's just done enough.
So it'd be the hardship does not result from actions taken by the applicant.
Yes.
Okay, is there anything else, Thomas, that you think we need to revise?
One moment, Mr. Chair. I would ask that you probably modify number 22. No permits were obtained for the deck construction I guess in 2019.
There should be, no permits were obtained for construction of the deck prior to acquisition of the property by the applicant.
Okay, that's fine.
Because we don't know when that deck was constructed. It could have been 15 or 11, but I mean.
Yes, that's actually a better statement. And just to make sure.
What about 21 though? Don't we have to do something for that? The hardship result of actions taken by the applicant since we changed it in the conclusions of law?
Yeah, but a hardship is not the result of actions taken by the applicant.
Okay. Thank you.
Is there anything else?
I think that's the only thing yes, I think that's everything.
Okay. Is there a motion to approve the findings of fact and conclusions of law as amended?
I make a motion to approve the findings of fact and conclusions of law as amended.
Thank you. We have a motion from Wilson to approve the findings of fact and conclusions of law as amended. We'll take a roll call vote. Mrs. Dryden?
Yes.
Mr. Wilson?
Yes.
Mr. Floyd?
Yes.
Ms. Long?
Yes.
Sanderson, yes. So those are approved. All right, our last case is case number 2020-124. Sitting on this case, that's myself, Mrs. Dryden, Mr. Welch, Ms. Long, and Mr. Floyd. All right, Lisa.
Okay, the next case is case number 2020-124. It's a residential street access variance. The applicant is requesting to construct a single-family home on an existing lot that does not abut a street, and I'll give you a minute to look over your findings.
All right, go ahead, Lisa.
Okay, slide number 1 is a vicinity map of the subject property. Slide number 2 is the zoning map of the property. The property is zoned R5 single family and is located in the Lake Wiley Protected Area Watershed Overlay. Exhibit number 3 is an aerial map of the property. And exhibit 4 is a close-up aerial map of the property. You can see the property is shaped kind of like a triangular shape, and it is not abutting Nance Road. Government exhibit number 5 is background. The subject property is a non-conforming vacant lot that was in existence prior to 1989. A 15-foot wide access easement for the property is shown on a plat from 2020 when the property to the south was subdivided. Government Exhibit 6 is the variance request. The code requires that lots that do not abut a street be at least 2 acres in size and be served by a 15-foot wide exclusive easement in order to be permitted a single-family home. The subject lot is just a little bit over an acre in size and is served by a 15-foot wide easement, but it's not designated as exclusive. The applicant is requesting a variance from the minimum lot size and requirement for an exclusive easement to construct a single-family home on the property. Exhibit number 7 is considerations. Staff supports the requested variance. The hardship's not a result of actions taken by the applicant. The applicant states that the lot did not abut a street prior to their ownership. The requested variance is in keeping with the intent of the zoning ordinance. The 1 acre size exceeds the 5 unit an acre minimum density required in the R5 zoning district. The requested variance is in keeping with neighborhood character. The lot predates the ordinance. The requested variance does not impact public safety because a 15-foot wide deeded easement provides access to the property. Government Exhibit 8 is a photo of the location, kind of looking in towards the property where the easement is located. And we also have the applicant on the line, and several people signed up to speak in opposition to the case. And that's my presentation if you have any questions.
Okay, thank you, Lisa. Are there any questions for Lisa from the board? Okay.
But so where did the easement come from? Is it from a neighboring property owner's?
So it's listed in the deed for the property, and also it was shown on several maps. It was shown on the plat that predated this plat, but this is the most recent plat showing it. So this was from when they subdivided these properties to the south. So this used to be 1 lot, and it got subdivided in 2020, and so they showed the easement on there.
Thank you.
Hey, Max, who is signed up, or who's signed up to speak on this for this case?
We have a Miss Eddie Bailey, Mr. Henderson Reed, Miss Phyllis Gaston, and Miss Sandra Mickens, as well as the applicant, Miss Fox. And all the applicant is unmuted, and all the other people are made panelists, so they should be able to mute and unmute themselves now.
All right, before we get started, Ms. Rob, Sandra Nicken, Anderson Reed, do you swear to tell the truth, the whole truth, and nothing but the truth in the matter at hand?
I do.
Yes.
Okay.
Yes.
So,
Yes.
Ms. Fox, just since you're the applicant, you can go ahead and make your presentation or say what you want to say about your case.
I just want to say that we obtained this easement about 22 years ago. And like Lisa said, it was included on those surveys for those new houses that just were built 6 months ago.
Okay. Is there anything else you want to say, or?
The only other thing is I noticed that the second house was put back further from the street. I thought it was because of the easement that we had for our land. That's all I have to say.
All right, thank you. So let's go with Eddie Bailey. If you have comments for or against, please let the board
Good
know.
morning. I'm just here because I received the information. My property is not really involved, and then my brother's property is right because he has a house, but mine is a vacant lot. And my only concern was to make sure, because they did some changes. They changed Morris Chapel Road into Old Morris Chapel Road, so it backs up to my property. I just want to make sure that the road is not coming out on my property. And from what I understand, we received the information because I think he said it had to be a 300 to own. I own land within 300 feet of where they're gonna build this house, and as long as it doesn't come out on my property, I'm good with it. But my brother wanted to make sure of that.
Okay, Lisa, do we know which property Bailey has?
I'm not sure what.
It's actually 9100 Old Morris Chapel Road.
Okay, so that would be on the road over here. Let me see if I can.
Yeah.
So that would be along this
Right.
one?
Yes, because
9100?
yes, and then the
Okay.
9112 is right beside it. Yeah, we own that property.
Okay, so the home nor the easement would affect your property. The
It
home
would.
it would not.
Okay, okay.
So it would be on this parcel that has the star on it, and then the easement for that property is going to be on 227 Nance.
Okay, okay. I just wanted to make sure because I don't know anything about printouts, and I know what Max told me, but I just wanted to hear from myself so that I would make sure, that everything was okay. And my brother is listening in. Okay.
Okay, well, thank you.
All right. Thank you.
All right, next up, Aston.
Hi, can you hear me okay?
Yes.
Good afternoon, everybody. Thank you for taking the opportunity to hear our part into what's going on or how we feel about it. Thank you so much. I am in opposition to this variance because first of all, I have questions. I have lots of questions about it, and I'm like the previous person. I want to make sure that it's not going to affect our property, its value, that it's not going to, breed any kind of, cause any criminal, change, change things as it relates to, the peace and, all of these things that we enjoy as landowners and homeowners. So my first question, I wanted to ask was pertaining to, I see that she was approved for an easement more than 20 years ago. And, I think it's kind of strange that, you come back in 2021, and present an application for a variance because she's short of what she needs to actually build the house. So I'm just kind of fuzzy about why she waited for 20 years. Okay. My second concern is the location of it. Looking at the map that was sent in her application, the survey that was done, it shows our property is the Roosevelt Cook property. I'm looking at that, and it appears from the map that this home would be very, very close to our property. And
Which property, excuse me, Ms. Gasson, which property do you own?
It's the Morris 9228 Old Morris Chapel Road property.
Okay, so you were at the very, very point of her, you would butt up to the very point Fox's property.
Exactly.
Very small portion
Exactly.
of her property, okay? And the
Yes.
driveway's on the very other end.
Exactly. And so, you know, she's extremely close. And you know, I'm just concerned about the proximity of it, you know, the closeness of it, the location. It's just kind of in a strange place. You know, you have property owners all around, and she's kind of like in the center, based on this survey that I'm viewing. So I'm just, you know, I'm concerned about the location of it, the timing of it. You know, land is selling. It's the value of our land. You know, I'm concerned about what if the variance is granted, how it will affect us being so close to Ms. Fox or the property that the house she wants to build. I just don't want to, you know, to be negatively impacted if this variance is granted for her to build her home. You know, so I'm very concerned about location and the timing of what she is trying to do at this particular time.
Okay. Well, we can ask her that when we get through everybody's. Try to get an answer for you.
I may have something a little later on, but that was my main thing is her location and timing. I'm concerned if she's going to live in this property or is she going to rent it out? And if you have renters in, you know, they transitional, you know, people come, people go. You know, again, I say I'm concerned about, you know, if it's going to affect the value of our property. Is crime going to be affected? You know, so there's just questions. We've been in this area a long, long time, and I don't, you know, just go ahead. So yeah, I just want to have those questions answered, and you know, we'll go from that point.
All right, Ms. Fox, do you want to answer those questions, or you have any comments?
I wanted to answer a question about the reason why there's such a delay. Yes. I mean, I'm presently living here myself at 9,000 Morris Chapel Road. The reason why there was a delay in the variance from before was because we tried to build a house down there 22 years ago, but because we didn't have city water or sewer, we couldn't build it there. So I just decided to build up front. That's the reason for the delay.
Oh, so you just changed your location as to where you wanted to build because you didn't have.
Exactly. So now I have a family member that wants to build a house, and now we have to do this now. That's the reason.
Mm-hmm. Okay. And is this something that, I mean, I just need to know because you're at the point of our land. You're so close. You know, is this something, you said a family member, so it would be owned,
Yeah.
it would be something that you would be renting out to, you know.
No, that's why I want to do it for a family member now, because I have so many people calling me for the land and I don't want to sell it. I want to keep it in the family.
Oh, okay. Definitely understand that. Definitely understand that. Okay. Thank you, Ms. Fox. I appreciate that.
All right. Next up will be Sandra Nickens. All right. Question read then.
Good evening. I'm 208 Nash Road, and I am for this project. I've lived here all my life, and basically, the applicant has gone through the procedures of getting the documentation that she needed to have that right of way, if I understand correctly. It was documented. And the builder who built the houses here in the last couple of months, if you noticed, he pushed one house back quite a distance to allow for that right of way to their property. And so I am for it. I didn't sign up to speak, but I appreciate you giving me this opportunity to speak. And I don't see any problems. This is the only area in the Charlotte hasn't been developed. We're trying to develop, and people are trying to buy all the property that is not developed. So we have a homeowner here who owns the property, has lived here, and is trying to develop it. And I see no problem if it meets all your criteria for them developing property. They didn't have access to it, and this would give them access to the property.
All right, thank you. So I think that's is Sandra Nickens still on, or you want to make a comment or not?
To get clarity, I was looking at the application I got offline, and I just wanted a little bit more clarity on how here I'm reading, we'll create a passageway for the public access, but I think all that has been addressed, and I am very concerned about the close proximity to our property at 9228 Old Moores Chapel Road. So I'm just listening in, and I was concerned about the valuation as well of our property.
I don't know where 9228 is. So.
If you look at the map, it says DB 3189-593.
Lisa, can you point out on figure 2 or figure 2 for me?
I don't have the document that she's referencing. Is it this large
9228.
parcel?
Yes, it's the same property that we were discussing earlier with Ms. Gaston.
Okay. I think it may be this property right here.
All right, so you're at the very end of the property then. Okay. Yeah, I mean, based on what Ms. Fox said, I think you've heard what she said. Hopefully, I mean, she said that it's building a house for a family member. And she's owned the property for over 20 years with the driveway easement. So, and she lives out there currently.
Okay. I'm just here for clarification.
Okay. Well, I think that's what she said. So I don't have any other information than what she's provided.
Mr. Sanderson, I'm sorry. This is Phyllis Gaston. If I may interject at this point, please. I wanted to just get verification as it relates to the road that needs to be built as it relates to proximity to our property. You know, one of the previous callers wanted that assurance as well, that the road wouldn't be, you know, affecting our property. Can you tell me if that road would be affecting our property or not, please?
I don't know what road. The only thing that this hearing is about for this case, for this variance, is the is the ability to build a home on this property with a 15-foot easement that's already been granted it's already been deeded to this property coming off of Nance Road, right at the bend of Nance Road.
Okay, so what I'm looking at on this map is all that she's requesting. So we won't have to worry about that on our property at all. This is it. There's no hidden. There's nothing else that she's gonna want other than what we see on this map.
As far as this board has been told.
Right.
Mr. Chair.
Yes,
Thank
Mr.
you.
Powers. Yes. Thank
If
you.
I may weigh in on a few issues, maybe for the individuals who are interested as well as the board. Number one, this board cannot grant property rights to the applicant on someone else's property. So any questions or concerns related to a roadway or anything of that nature on someone else's land, this board has no authority to do that. Any roadway would be something that's already existing that would be used for the subject property in question. So that's number one. Number two, and this is primarily for the board, any consideration of the use of the property for a family member should not be considered. That residential structure can be used however the property owner sees fit, either by giving it to a family member, renting it out, or selling it to someone else. That is not something within the purview of this board in that regard. So I just want to make sure I at least clarified that as we're having these discussions for the board's consideration, as well as the applicants and other interested parties.
Thank you, Mr. Powers. I appreciate that.
Thank you, Thomas. All right, Max, is there anybody else signed up to speak?
No, that was everyone.
All right. Any questions for Ms. Ford?
I'm not sure if this is a question for Ms. Fox or the staff, but are there any limitations on like the size of the home that can be constructed here? Or is it kind of carte blanche, she can do whatever she wants?
She would have to adhere to the setback requirements in the yards.
Okay.
All right. Lisa, is there anything, final comments from staff?
No final comments.
Excuse me, can I ask the question? Since the property, I guess the house is zoned R5, aren't there requirements about the size? What the lady was asking, the size of the dimensions of the house, like maybe no more than 1,000 square feet or something like that. How can I put it? Like you can only build X amount on like an R4 or R5. Does it have to be like, say, maybe 1,100 or 1,200 square feet? You see what I'm saying?
So let me just say this for the board's situation here. Some of the questions that are being asked, it is not the board doesn't want to answer those questions.
Okay.
It is that those questions may be better directed to Mr. Spencer, because the board has a very narrow issue that they're looking at, which is whether or not to grant a variance which will allow the property owner to build a house. As to how the house will look, how tall it will look, particularly the orientation of the front door and the roadway. A lot of those questions would be better directed to Mr. Spencer, because this board would not actually get into those type of design schematics and details. So it's not that we don't want to assist you in that regard. It's just that the board is not the proper person to answer those questions. Mr. Spencer, who is on the actual meeting at this time, I would say you reach out to him directly, and he can answer each and every question that you're having related to the underlying zoning and the requirements, and also keep you informed of any issues related to the permitting process if this board were to grant the variance today.
Okay. Thank you.
No problem. Just to make sure, and Mr. Chair, I apologize for this. Do each of you have Mr. Spencer's contact information, or have you emailed Mr. Spencer prior to today's meeting?
No, I don't have.
Can you put it in the chat? Is there?
We would do that.
Okay,
Yes, ma'am. We would do that. So I just want to make sure about that. I'll take care of that in that regard. Mr. Chair, I turn it back over to you.
Thank you, Mr. Powers. All right, Ms. Fox, I'll give you the final word on the case before we go into deliberations.
No, I just want to reiterate, thank you for your time, for hearing my side of the story. And I hope we can get this taken care of. Thank you.
All right, thank you. I'll go ahead and close the hearing then. We'll start deliberations. Let's start with Mr. Floyd.
I would say I'm leaning towards granting this variance. I think, again, if you look at the 4 factors we have to apply, unnecessary hardship. I mean, it sounds to me like the hardship here would be no use could be made of this property. It's zone residential, and basically you wouldn't be able to actually build anything on it. I think that's a pretty significant hardship. It does result from, the peculiar nature of the property and where it's situated versus the roadways. Didn't hear any evidence that, this was something that the property owner did. And I think it is consistent with the spirit, purpose, and intent of the ordinance. Although the property isn't 2 acres, it's still a larger property. The property has an easement across the corner of a neighboring property for access, which, even though it's not an exclusive easement, I think, it's not a huge stretch to say that allowing it based on the fact that it has an easement is consistent with the purpose of the ordinance. And again, I just go back to the hardship here. The impact would be so great that I think that weighs heavily in favor of granting the variance. And so that would likely be what I would do.
Thank you, Mr. Floyd. Ms. Long?
I would agree. I'm fine with the proposed. I'm inclined to agree to approve it.
Thank you, Mr. Welch.
Echoing Mr. Floyd, I am inclined to agree to approve this variance.
Okay, Mrs. Dryden.
I vote to improve. I mean, I'm in favor of the variance, especially since we have evidence that the easement has been in place for 22 years. So she has the right to have access to the property. So I have no problem approving this request.
I agree with my colleagues' comments. So is there a motion?
I make a motion to approve the variance.
Is there a second? We have a motion by Mrs. Dryden, and a second by Mr. Welch to approve the variance. We'll take a roll call vote. Mrs. Dryden.
Yes.
Mr. Welch.
Yes.
Ms. Long.
Yes.
Mr. Floyd.
Yes.
Sanderson, yes. It's approved. Let's look at the findings of fact and conclusions of law. I didn't see anything, but Thomas, I'll take your advice if we need to beef up anything or add anything to it.
Mr. Chair, I did not see anything to recommend.
All right, thank you, Mr. Bowers. Is there a motion then or changes to be made?
Make a motion to accept the whatever.
Findings of fact and
The
conclusions
finding
of
of
law.
fact. Thank you. I lost my word. The finding of facts and the conclusions of law.
All right, we have a motion by Mr. Bowers to approve the findings of fact and conclusions of law. Is there a second?
I'll second.
So, Welch, take a roll call vote. Mrs. Dryden.
Yes.
Welch.
Yes.
Ms. Long.
Long, yes.
Mr. Floyd.
Yes.
Sanderson, yes. So those are approved. Our last piece of business, appeal of variance case 2020-032. Mr. Powers, the floor is yours.
I will actually communicate with you all offline. Thank you.
All right. Thank you. Is there any other business that needs to be addressed? Max or Lisa or Thomas?
No, sir, not at this time from the city attorney's office.
Okay. Max, anything else from staff's part?
I'm not aware of any other business on staff's end.
All right, then y'all have a good rest of the month and a good February and stay healthy and safe, and we'll see see you remotely, if not in person, at some time in the near future, definitely in February. I call the meeting to a close. Thank you.
All right, thanks.
Thank you.
Thanks.